Here's your kid. That's allegedly what a woman told her ex-lover when she handed him a small cooler. And inside, it's the stuff of nightmares. We are taking a closer look at this horrifying incident and what could become of the suspect as her court case moves forward. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. This is a story we might not really believe if it weren't in the black and white of a police report, and I really wish it wasn't, but it is. Because Missouri investigators say that a woman claimed she had a miscarriage and decided to give the remains to the alleged father of the child in the most cold and callous way I think I have ever heard. That's the allegations. Now, we're going to warn you, these are incredibly disturbing allegations and are very tough to hear. 29-year-old Makayla Annette Haedt is facing a harassment charge, and a probable cause affidavit filed in support of her arrest lays out what led up to that charge. So to help me talk about what law enforcement says happened, discuss where the investigation goes from here, where the case goes from here, I want to welcome on trial attorney Allie Young. Allie, thanks so much for taking the time. Appreciate it.
Yeah, thanks for having me.
So this deputy with the Pulaski County Sheriff's Office wrote in this affidavit that he responded to a home in Waynesville, Missouri on September 18th. This is just before 3 in the morning. And he spoke with a man identified as confidential victim number 1, or CV number 1. So we believe this to be the alleged father, right, Allie? First of all, why keep him confidential in this report?
We just like to protect victims' rights here. Just having a kind of a buffer between who the victim is and who the public knows him or her to be kind of creates a little bit of a safety net for any victim. So not just him, but any victim, we tend to refer to them by their initials to give them a little bit more anonymity.
So the affidavit reads, quote, CV number 1 and the female subject, identified as Makayla Haedt, and I believe that's how you pronounce her name, could be wrong, apologies, have been friends for a few years. During those years of being friends, they had been romantic with one another on and off, stating, "We never dated, it was more of a fling." He stated Makayla was a habitual liar, which caused him to not believe her when she advised him she was pregnant approximately 1 to 2 months prior. CV1 told me earlier in the afternoon of September 17th, 2025, Makayla had messaged him stating she had a miscarriage, but did not say anything else on the subject. Makayla then came to CV number 1's residence and picked him up in her vehicle, where they then went to run errands. Now, Allie, this gives us some kind of background on not only the relationship between the victim and Makayla, but also how she interacts with him after apparently telling him she had a miscarriage, right? The whole thing is written in a way that sounds so nonchalant.
Yeah,
I guess the question
callous.
is, if this is the account that was told to him by CV1, just taking there, is CV1, this apparent father, most reliable narrator, given what the timing of, just told this, and then what are we talking about?
Right. Like, why does he not have more questions? She just said she went through a miscarriage. Any normal person would kind of have concern for another person that maybe went through a miscarriage of their own child. But outside of knowing more about what's going on during the background of their relationship, or, I mean, he does say, hey, she's a habitual liar, I don't believe her. But at the same time, we don't know how far along she was or anything of that nature. It reads very callous, and it reads very kind of juvenile.
And to be clear, from this story, we can't even be certain there was a miscarriage per se. Let me get into this a little bit more. So the affidavit continues, quote, at approximately 20-30 hours, once back at his home, CV1 was burning trash where Makayla threw what appeared to him as a Walmart bag containing clothes into the fire. Allie, just before she hands him the cooler, which we'll talk about, she apparently burns this Walmart bag. Now, law enforcement seems to posit that the bag contained clothes. Are we talking about destroying evidence here?
I don't think there's necessarily evidence there, because there would need to be just destroying clothes doesn't necessarily lead to any sort of a crime, especially if we're going to talk about is there a fetus in a cooler, or is there a baby who was once alive? So those are two very stark differences that we have to kind of acknowledge here, as far as Missouri law acknowledges. If it's a fetus and it never once had a breath of air coming out, then there's no life to give it under Missouri law. If it's an infant and it died during the course of childbirth in any capacity, but at one point in time after it has been born, it took a breath, then we can talk about, oh, that's a live fetus. So Missouri law kind of gets a little bit iffy in that gray area. But if we're just talking about a bag of clothes, there's no evidentiary value that says this would have led to something more nefarious.
Now, obviously, this is a story that we wanted to bring to you. And the reason that we can do this is not only because of the amazing support that we get from all of you out there, but also from our incredible sponsor, Upside. Now, Upside's the free app that gets you cash back on daily essentials like gas, groceries, food. I pump my gas, I can use Upside. I go out to lunch, I can use Upside. I get something at a convenience store, I can use Upside. And why not get cash back when I do all these things, right? This is actual, real cash back. It's money that appears in your Upside app that you transfer straight into your bank account. Once you have the free Upside app, you claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card. You follow the steps on the app, you get paid. To find out how much you can earn, click the link in the description to download Upside or scan the QR code on screen. But make sure to use our promo code Sidebar because you'll get an extra 25 cents back on every gallon on your first tank of gas. Yeah, that distinction is important. And let me get to this part. This is the main part of the affidavit that is just gut-wrenching. Quote, Makayla then gave him food, which she had gotten from a Good Samaritan, where she then handed him a red and white in color cooler with green tape holding it closed, stating, "Here's your kid," then driving off in her vehicle. CV number 1 said he believed she was making a cruel, bleeped-up joke, and instead believed it was a cooler of drinks, but was hesitant to see the contents. He placed the cooler on the ground where he sat next to it, trying to decide what to do with it, in fear it may actually be a deceased fetus. CV1 said after speaking with family members and friends regarding what he should do, approximately 1 to 1.5 hours later, he decided to have his friend D accompany him to see what was inside the cooler. After opening the cooler and observing the fetus, CV1 then closed the cooler and called the sheriff's office. Allie, this is so disturbing. It is so unthinkable. My question is, I have a lot of questions about this. First of all, do police conduct testing to see if this is in fact his child, to see if in fact this is her child? I mean, how do they process this?
Sure. I mean, so they invite a coroner to the scene to try and figure out, one, is this a human fetus? Two, then they try and decide, did this baby ever live, or is this in fact a miscarriage where the baby was dead prior to being born? That all happens later on. It doesn't happen specifically there at the scene, but they could do a DNA test. They could try to see if it is related to CV, but based off the charges, there's no real need to do so. The paternity of this child doesn't necessarily matter in the eyes of the law as far as what Ms. Haedt is charged with.
And the idea of the sequence of events, right? She allegedly drops off the cooler, leaves. He doesn't know what to do, according to the account, has to call a friend. I mean, that is so chilling. And I wonder that sequence of events, how that fits into the investigation.
Well, something that really stood out to me in the probable cause statement is when CV tells the officers, he even apologizes to the officers for them having to see the fetus in the cooler. He says, "I'm sorry you guys had to see that," knowing this is something that nobody wants to see. This is an image that's going to haunt CV. It's going to haunt the officers. It's going to haunt everyone that's involved in this case, just because of Ms. Haedt's cruel decision to leave the body in the way that she did.
I'm glad you mentioned that because the affidavit says, while speaking with CV1, I observed he would often become silent where he would stare at the ground for several minutes, then make a statement such as, this is the type of thing you see on the internet all the time, but don't think will happen to you. And this is bleeped up. I'm sorry you guys had to see that. CV1 appeared to have tears build in his eyes while speaking about the incident and had a hard time describing what he felt when he initially opened the cooler, but said once he saw the fetus, he was shocked and couldn't believe she would do something like that. Now, Allie, officers, they always assess credibility of the witnesses they're speaking to. What does that account tell you? And the specifics of it, the emotion of it, to put it in a report. The officer, the deputy, thought it was relevant to make note of that.
Yeah, absolutely. Anytime the complaining victim is experiencing such a high level of emotion, it definitely is important, and it shows through the probable cause statement how hurt that the victim was. And if you can just read on paper how hurt somebody was, then there's no level of feeling it in person. So I couldn't imagine in person what he is actually feeling, because I can read it on paper and I can just see how hurt he is through that.
And it's a great point because that actually ties into the specifics of the charge that Makayla is facing, okay? We will get to that because it's not only just opening a cooler and seeing a fetus, right? The shock of that, how disgusting it is, but to think, or you were led to believe this is your own child, right? That goes beyond. So the deputy writes, in order to verify the contents of the cooler, I carefully opened the cooler where I observed what appeared to be a human fetus. So now you have the deputy confirming what was in there. After shutting the cooler and asking CV1 to move away from the area, I advised dispatch to notify detectives and the coroner. Now, the deputy made sure to note in his report that part of his interactions weren't recorded on his body cam. Quote, after leaving CV1's residence, my body-worn camera malfunctioned, causing it to only save the footage leading up to opening the cooler. Allie, why is that important? Why make note of that? How much of a difference does that make?
It doesn't make a whole lot of difference. It's just a procedural thing. So it shows a defense attorney or a prosecutor who's going to eventually get this case that says, hey, nothing else of substance happened after my body cam turned off. I just left and it malfunctioned. Everything of substance happened while the body cam was on, and then I left the scene and my body cam stopped working. It just kind of clears up any questions about what's going on after the body cam cuts off that a defense attorney or a prosecutor might have of the case.
So let's talk about what reportedly happened next. According to court documents, deputies were able to locate Makayla's car, this Ford Fiesta. They took it into custody for processing. She was arrested. She was booked into jail. Around a $50,000 bond has been set. And court paperwork reads, Makayla committed harassment first degree when she, without good cause, gave CV1 the cooler containing a deceased fetus, stating, here's your kid, causing him emotional distress. Now, I'll talk about that charge in a second. First, Allie, taking the car in for processing, what are they looking for?
Sure. They're looking for, I believe they're looking for any evidence that says that maybe the baby could have been alive at the time of birth. That obviously then elevates this case significantly from the E-level felony of harassment in the first degree to an infant homicide or to an endangering the welfare of a child first degree, which is an A felony. I think, but just based off taking the car into evidence, that's what they're looking for. Can they find anything that would suggest that the baby was alive prior to it going into the cooler and then being handed to CV?
And I want to talk about that. But first, so she's facing this harassment charge in the first degree. I looked it up. It says a person commits the offense of harassment in the first degree if he or she, without good cause, engages in any act with the purpose to cause emotional distress to another person, and such act does cause such person to suffer emotional distress. So now, Allie, we can see why the deputy is putting in those specifics about how CV1 was reacting into that probable cause affidavit.
Yes, the deputy knows at the time of writing his probable cause statement exactly what he's going to ask the prosecutor to charge. And based off of what he thinks the evidence is, that's what he's going to write in his report to kind of bolster that claim. So a probable cause statement just is everything the officer observes and sees that could bolster the claim that he is making in order to get the charge that he's asking for.
And that's pretty straightforward, the harassment charge. It feels kind of broad. It can include a lot, but I mean, it seems like a law school example. If all the facts are true and you put a fetus in a cooler, hand it to somebody and say, this is your child or here's your kid, it feels like a textbook, clear-cut case of harassment.
Exactly. The harassment charge in the state of Missouri is all encompassing. It can include, hey, this person threatened me by racking his firearm and putting a note on my doorbell saying that that's for me, or it could include sending harassing text messages that somebody's going to regard as offensive, and it can include putting a fetus in a cooler, apparently.
By the way, this harassment charge, you seem to, and I don't want to put words in your mouth, you say it's possible this can be upgraded if we're talking about whether that baby was alive. And whether or not the baby was killed. Because, I mean, how do they confirm whether or not she had a miscarriage or not? But beside from that, can there also be another charge? I don't know if there's something in the books for, desecration of remains or mutilation of a corpse or tampering with evidence or something like that. Is there something else that you think, based purely on these facts or the facts laid out by law enforcement, more that she could face?
I think those are great options for the prosecutor if they want to explore that route. I think going the route of trying to see if the fetus was alive at any point in time is a big stretch. That's very hard to do, and it's going to require a lot of expert testimony in order to establish that. But tampering with evidence is a good additional charge. And like you said, that would just go towards, hey, you're taking evidence of this fetus, you're putting it into a box, and then you're giving it to some random person on the street. That's a crime. But also, it doesn't necessarily establish that there was a crime initially that there was a crime that was initially committed. So if you're going to tamper with physical evidence, that evidence has to be evidence of a crime to begin with. And if there's no evidence of that crime, the underlying crime, then you can't tamper with the evidence.
Given this heinous series of allegations here, are we potentially looking at some sort of mental health defense, or at the very least, a competency evaluation that may become a priority in a case like this? I haven't seen anything to suggest that's what we're dealing with, where she, can't appreciate, the charges against her, or provide, assist in her defense in some way, or understand the legal process, because that's different from, let's say, insanity. But I do wonder, taking these allegations as true, if Missouri provides for a mental health defense and what that may look like.
Yes. So I did a quick CaseNet search of her name, and it shows that there are 3 pending cases currently for her. This one, and then 2 others. One misusing 911,
Yep.
and then a DWI. The 2 of those are very benign charges anyways. They're misdemeanors. However, if you read into them and you read their probable cause statement, I mean, it gives rise to a defense of diminished capacity, which is the question, what goes to your question as far as an insanity defense outside of, is she completely competent? I have no doubt she's competent. That's a very low standard to meet. But if there's mental health issues there, I would say this case probably has all the hallmarks of it, especially if there's some sort of underlying mental health issue, and then pregnancy on top of it does compound those mental health issues. It can certainly lead to questions of whether or not her mental status and her capacity are there in order to commit crimes.
Yeah, because the idea of just handing over a cooler to somebody with a fetus inside, right? That's the allegation. Knowing they're probably going to call law enforcement, it does raise those questions. And by the way, just adding to something that you said, you're right. It seems, based on the court records, that Missouri law enforcement have encountered her before. So in July of this year, according to court records, it's our understanding, Makayla was pulled over for crossing the center line, having a broken tail light. And according to the officer's report, she was argumentative with a state trooper, tried to call 911 on him multiple times during the stop. At one point, the trooper notes that she has her phone between her legs, and it turns out she's connected to dispatch. The dispatcher reported that Makayla had called multiple times to report she was being harassed by an officer. And the probable cause statement in that case reads, Haedt had contacted Troop F and 911 5 times within a 10-minute period. Now, there is an interesting tidbit from that affidavit. It ties back in with this disturbing case because the trooper wrote that her behavior was, quote, extremely erratic. During questioning, she stated she was a little dehydrated and pregnant. She was charged with a misdemeanor in that case, misuse of 911. But when she failed to show up for court, there was a warrant that was put out for her arrest. Allie, just to circle back on that, do you think that will play a role in the current case?
I think it would definitely, as a defense attorney, I think it would definitely play a role in my eyes. A prosecutor may try and sever them and say, obviously, she knows the role of 911. She's calling and she's asking for help. She certainly could have done that in this case. However, as a defense attorney, I'm using all that I have available to me, and that right there kind of bolsters my claim for she has a diminished capacity. She's not able to appreciate the mens rea or the mental status needed in order to commit harassment in the first degree.
And I want to just focus on that harassment charge for a minute, because the charging information that was filed with the court, it laid out the sentence that she could face if she's convicted. You mentioned it, a Class E felony. It says, quote, the range punishment for a Class E felony is imprisonment in the custody of the Missouri Department of Corrections for a term of years not less than 1 year and not to exceed 4 years, or by imprisonment for a special term not to exceed 1 year in the county jail or other authorized penal institution, or by a fine not to exceed $10,000, or by both imprisonment and a fine. Now, Allie, that's our understanding about how this would work here. If she takes this to trial, if she's convicted, what do you think she would be looking at here? Again, assuming the charges aren't upgraded.
Sure. If she goes to trial on the harassment case, a 1 to 4 year sentence in prison, it's a non-85%er, so she would do probably somewhere around 30 to 35% of whatever time is given to her. Additionally, she wouldn't even have to serve time. This is not a mandatory prison charge, so she could receive a probation, an SIS probation, which is a probation that doesn't carry a conviction, or an SES probation, which would carry the felony conviction. So there is a wide range, but it's not the harshest of ranges that she could face, obviously.
I gotta say, I mean, if she's convicted of this, it doesn't get more egregious. I would have to imagine there'd be prison time, which does make me wonder if this is all that she's facing right now. Would a plea be a plea bargain be put forward in this case, a plea deal? Why? I wonder if prosecutors really want to take this to trial. Do they want to expose a jury to photos of a fetus in a cooler? Do they want the family? Do they want anyone to be a part of this? I would imagine avoiding a trial could be a great decision here. However, offering no prison time for, if these allegations are true, offering no prison time for something like this to avoid a trial, I don't know if that's in the best interest too, in the interest of justice.
Sure. In the interest of justice is an interesting question that we would face here. So I would want to know, I would want to get a psychologist and a psychiatrist involved. I want to know what's going on deep inside of this woman, because as a mom and as a member of our society, I mean, you would have to think that there has to be something that is deeply rooted in Ms. Haedt in order to for these facts to be true. Even just a member of our society, you would want to make sure that okay, let's take care of the underlying causes that is making Miss Head do these crazy things, because 1 to 4 years in the Department of Corrections is no time at all. And so at some point, regardless of if she gets 1 year or 4 years, she's getting back onto the streets, right? And so we want to make sure that we're addressing whatever mental health concerns there is at the time, whatever issues that could be kind of wrapped up in Miss Head, and then trying to put her back into a position where she can be a contributing member of society when she's done with this case, and that we're not going to keep seeing her in the justice system. This is a case where you have to ask yourself, like you said, what does serve justice? And I don't think 4 years is ever going to be enough for CV, who has to see these images of this baby for the rest of his life, or the officers for the rest of their life as well. But also, does this defendant have severe mental health issues that have caused her to do this? Those are what I would weigh on the scale here to try and decide what's appropriate and what's not appropriate.
Allie, thanks so much for coming on to talk about this case. I know it's not an easy one, but appreciate it.
Never is. Thank you, Jesse, for having me.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.